Okay, good morning, everyone. My name is Daniel Castro. I'm the Vice President of the Information Technology and Innovation Foundation. I'd like to welcome you to today's event, Outlawing Revenge Porn, How Congress Can Protect Privacy and Reduce Online Harassment. So, the goal of today's event is really to discuss this problem of non-consensual distribution of sexually explicit images, which is commonly referred to as revenge porn. The different types of responses that we've seen from government and the legislative steps that we can take to better protect victims. Before we get into this, just a few logistics. First, everyone knows this event is being recorded. If you want to participate online via Twitter, we're using the hashtag ITIF privacy. And we have a really fantastic panel today to get into this discussion. But before we get to that, the reason we're having this discussion here today, and I mean that both in a general sense as well as a literal sense, is because we have the privilege of hearing from Representative Jackie Speier. For those of you that don't know her, Representative Speier represents California's 14th Congressional District. She serves on the House Armed Services Committee as the ranking member of the Subcommittee on Oversight and Investigations and on the House Permanent Select Committee on Intelligence. But perhaps much more importantly, she's been a tireless advocate for women's rights and a champion for the safety, health, and rights of ordinary Americans. And this is why Newsweek has named her to its list of 150 fearless women in the world. And I think one way she's demonstrated this fearlessness is through the writing and introduction of the Intimate Privacy Protection Act, or IPPA, the first bill in Congress that really takes on this issue of revenge porn. And not only does this bill outline what I think is a responsible path forward for lawmakers, but it's really brought this discussion to the forefront and created an opportunity and a space for us to have this type of a conversation. So we're very delighted that you're here to talk with us today about your motivations for the bill, the current status and outlook, and where you see things going from here. So please join me in welcoming Representative Speier.
Good morning, everyone, and thank you to Daniel and all of you for really being here, because this is really a very important issue. Special thanks to the Information Technology and Innovation Foundation for putting together what is a pretty impressive group of experts on this issue. And I really applaud the panelists, all of whom most of whom I know and really admire. I hope this doesn't come as a surprise to you, but the internet is not the same place for everyone. For the fortunate, it's a place for open and thoughtful debate, for witty banter, and cute cat pictures. For some, and this includes mostly women and ethnic minorities, it can be a place of unrelenting sexism, racism, verbal abuse, and even death threats. Now, as a public person, I sort of expect some of that, and believe it, I get plenty of it on the internet. But for the average person, this is not what they expect. Take the recent experience of actress Leslie Jones. For doing nothing more than starring in a remake of a movie about fighting ghosts, she was subjected to a never-ending stream of racial epithets and sexualized threats. She left Twitter, but the abuse didn't stop there. It culminated in her personal webpage being hacked and intimate photos being posted publicly. Jones' case is regrettably typical of the experience that many women, and especially non-white women, have on the internet. For them, the internet has become a new age sewage pipeline carrying the worst material imaginable in endless quantities. And as social media proliferates, so too do these opportunities to destroy people's lives. Several years ago, I started reading chilling stories of young people committing suicide because their image was being distributed without their consent. Audrey Pott, a high school sophomore in San Jose, committed suicide after photos of her sexual assault were passed through Facebook, Snapchat, and text. Reheda Parsons, a 17-year-old in Nova Scotia, killed herself after photos of her gang rape were posted online. Tyler Clementi, a Rutgers college freshman, killed himself after his roommate used the webcam to stream him having a sexual encounter with another man. Chrissy Chambers seriously considered suicide after her ex-boyfriend posted intimate photos along with her name and personal information to more than 35 different porn websites. Earlier this year, Anisha Mora spoke at a press conference I held to introduce the IPPA. Anisha described how she deactivated her Facebook account, changed her phone number, dropped out of school, and moved out of state after her ex-boyfriend posted private images that ended up on more than 3,000 websites. Anisha was stalked by strangers, including one man who pushed his way into her family's home and made it almost to her bedroom because her ex-boyfriend included a diagram of the house with her address, along with false claims that she had rape fantasies. It should come as no surprise then that more than half of victims of non-consensual pornography report having suicidal thoughts. This kind of abuse is widespread. The Economist has reported there are as many as 3,000 websites and millions of images and videos that feature non-consensual pornography. Carrie Goldberg, who is sitting on this panel today, is representing hundreds of victims of this abuse. Victims' rights groups like Cyber Civil Rights Initiative have been at the forefront of this issue and have been contacted by thousands of victims seeking help and justice. But these numbers, though appalling, are just the tip of the iceberg. That is because non-consensual pornography can stem from cases of revenge, as with Anisha's case, to images and videos of sexual assault being shared from prurient entertainment, as Tyler Clementi's case. There are even particularly disgusting cases where trusted caregivers have shared images they came across in their duties. One ProPublica study found that 35 incidents since 2015 have occurred involving nursing home staff posting graphic images of residents with dementia and other ailments. They should begin to wonder, what will people stoop to? As non-consensual pornography continues to spread, survivors have often been left with nowhere, absolutely nowhere to turn. Celebrities have hired high-priced law firms to demand that websites remove the material, and individuals with financial means to hire lawyers have sought civil damages against those sites that profit from posting non-consensual pornography. But even in these rare cases where they have the resources to do that, the images often still can be found on the internet. You can make a full-time job out of searching the internet on 3,000 websites to see if there are non-consensual photos of yourself being posted. A few revenge porn sites operators, like Hunter Moore, have faced criminal punishment, but that's only after they've committed additional wrongful acts of extortion, blackmail, and hacking, not for disclosing the images. Across the country, 34 states have adopted their own bans on non-consensual pornography. Some of these laws are carefully crafted, but many lack important elements, such as explicit First Amendment protections. Still others only punish non-consensual pornography when the perpetrator is motivated by a desire to harass the victim, which leaves perpetrators who are only interested in greed or voyeurism to continue to commit the crimes and abuses that we seek to address. This patchwork of regulatory schemes creates great uncertainty for victims and tech companies alike. All victims deserve recourse, not just those in some states, and all companies should be able to set policies that will apply nationwide. Only federal legislation can address all of these concerns. It was clear to me that there was a need for a federal law to address this behavior, but I knew it was not going to be easy. Some of you may know that the long path to the Intimate Privacy Protection Act, or IPPA, has taken over 2 years. I knew to get something done on this complicated issue, I needed to draft a bill that had teeth, yet could withstand constitutional scrutiny, and that would garner broad support in the advocacy community and from the tech companies. I also knew that we would need substantial bipartisan support from my colleagues. Now, most of this would not have happened without the talented chief of staff to help thread the drafting of this legislation. So I want to say to Josh Connolly, who is on this panel, without him, this would not be a bill that we are addressing today. After many revisions and with the help of Professor Marianne Franks in drafting the bill, we started vetting the legislation with constitutional scholars and legal organizations. After a lot of work, we lined up strong support from legal organizations such as the National Association of Assistant U.S. Attorneys and the National District Attorneys Association, and 12 leading constitutional law scholars, including the Dean of UC Irvine School of Law, Erwin Chemerinsky. Dean Chemerinsky has literally written the book on constitutional law and argued 5 cases before the Supreme Court. His take on our bill sums up the constitutional question well. Dean Chemerinsky says, and I quote, "There is no First Amendment problem with this bill. The First Amendment does not protect a right to invade a person's privacy by publicizing without consent nude photographs or video of sexual activity," unquote. You know, I never get tired of reading that quote. We also brought together a broad coalition of supporters, including online businesses like Facebook. I want to thank Facebook for being here today, and Twitter, and victims' rights groups like Cyber Civil Rights Initiative and the National Organization of Women. If passed, IPPA will punish individuals and websites that knowingly post private, intimate material, while also providing a safe harbor protection for websites that don't advertise or solicit such content. IPPA contains strong exceptions to protect free speech, ensuring that disclosure of private information that has been voluntarily made public or in a bona fide public interest would not be criminalized. Most importantly, IPPA would end immunity for revenge pornographers who continue to do their, quote, craft, unquote, because IPPA does not exist on a federal level. We have more work to do to get this bill passed. We already have bipartisan support. 6 Republicans have joined in this effort. I hope when I reintroduce the legislation in the next Congress, presuming I'm reelected, that we will have numbers that are extraordinary in support of this legislation, and that we will be able to get it to the floor. Today, with smartphones and endless social media platforms, there is no difference between online and offline life. It's all just life. The same technology that gives us numerous ways to improve our lives also gives us numerous ways to destroy. Fortunately, it's possible to protect both privacy and free speech. In fact, the Supreme Court, and this is very important to underscore, the Supreme Court has noted protecting privacy is often vital to protecting free speech. When people live in fear that there might be private information that can be disclosed to the world with devastating consequences, they cannot express themselves freely. The First Amendment does not require us to stand idly by as real lives are destroyed by virtual actions. Not only do victims of non-consensual pornography deserve justice, society must hold perpetrators of this vicious form of abuse responsible. A civilized society cannot shrug its shoulders and say, "Oh, but there's nothing to be done." Of course there is something to be done. That's why we must do something now to address this issue. It is already out of hand, and it's time for Congress to act. Thank you.
Thank you, Congresswoman. Now, there's a lot there we want to discuss, and I'm very pleased to hear your expectation that next year we're going to see this bill move quickly and with great bipartisan support. So we have a tremendous amount of expertise in the room. We also have a tremendous number of people in the audience. So we do have some seats in the back. If you're coming in, you can just fill in the back. Let me just briefly introduce our panelists, and then we'll get right into this discussion. Starting on my far left is Josh Connolly, who's Chief of Staff for Representative Speier. To his right is Terry O'Neill, who's President of the National Organization for Women now. To her right is Mark Eichhorn, Assistant Director of Privacy at the FTC, and Tiffany Davis, who's Head of Global Safety at Facebook. Who I also should add has been very active on a number of organizations around improving online safety. And prior to Facebook, she was also worked for the state attorney general. So I'm going to, just as background, be asking for some views on some of that previous work as well. And finally, to my left, Kerry Goldberg, who's the founder of C.O. Goldberg, a New York-based law firm specializing in internet privacy abuse, domestic violence, and sexual consent abuse. So thanks to all of you for being here. Let's just start off. Kerry, let me start with you. Because you've been working so closely with a number of the victims that this law is intended to address, and this is kind of the reason we're here. Can you talk a little bit about what you're seeing in your practice? What are the experiences that you're seeing with your victims, and the challenges that they have today?
Okay, sure. So I'm basically the lawyer that I needed when I was under attack by a malicious ex. And so I started my law firm focusing on sexual violence, online and offline, because I couldn't find a lawyer. And I was in family court and being told by a judge when I asked for an order of protection that I had a First Amendment issue. So what I'm seeing is that victims come to me and they're absolutely so distraught. Their images are all over the internet. Oftentimes they've been targeted by somebody known to them, and the images are spread from device to device, usually ending up at some point on a social media site. And my clients are 13 to 65, 90% women, but most of them are on the younger side of the scale, and they do not know what to do. They're absolutely terrified that they're never going to be able to get control back of their reputation. And at this point in time, nobody can get a job or a roommate or even a date without being Googled. So you just have to think about how would you feel if the first 5 pages of your search engine results are images of you fully exposed and naked, images that you never wanted anybody to see. So my clients are distraught. They're afraid of their future.
Thank you. Terry, let me bring into this conversation because there's obviously this problem affects both men and women, but women have been disproportionately affected by this. We'll talk about some of the gender nature of the problem as well as what you're seeing in this space and how your organization is trying to solve.
Thank you. And by the way, thank you to Representative Speier for bringing this legislation forward. Just thank you so much. Because actually, this is yet another tool that domestic violence abusers can and do use to stop women from leaving. Right? There's an intimate photograph or intimate video taken, and she doesn't think that it's going to be shared with anyone because she trusts him, because she's in love with him. And yet when she decides to leave, he holds this out and says, if you leave me, I will expose this to the world. It's absolutely a tool of intimidation that is available in domestic violence. It's also a tool of intimidation in the workplace, quite frankly. and think in terms of, for example, modeling agencies, or dare I say it, beauty pageant contestants. There are girls as young as 14 years old that come to work for modeling agencies, and you can imagine that it's entirely possible for photographs to be taken of these girls. They're lied to about what will be done with these photographs, and then that material is utilized to control them. It's a common tactic in sex trafficking. It's a common tactic in other forms of exploitation of women. So what I am very excited about this legislation is that this is a federal crime, that it can result in serious penalties, and that the women themselves know that the country is behind them, and that we will use all the power of the government to stop these abusive behaviors.
Maybe let me bring you in on this conversation, because you've obviously been looking at the kind of broader sphere of online safety for a while, and you've seen a number of challenges in this space, responses. How do you look at this issue, and how have you seen the issue grow? Because we are talking about it more now as opposed to 10 years ago, even though obviously this type of thing has existed for a while.
Well, so we've always had policies against this type of behavior. We don't allow people to be bullied or harassed, but a couple of years ago, we saw an increase in this type of activity, and we made it much more explicit in our policies that you cannot do this type of harassment.
And have you seen this issue? I guess how would you quantify the issue if you can? Because that's always been one of the biggest challenges. I mean, Carrie, you have so many clients, but still you're one lawyer. You only point to so many examples there. And we know this happens outside of it when people never even hire a lawyer. They never even get to that step.
I would actually say the question is in some way not how do we quantify it, because one single person having this devastating effect on their lives is enough to make it worth solving.
And Josh, let me bring you in on the conversation too. I mean, there's obviously this kind of question of when should government get involved, always, right? And when should the federal government get involved? So what was the kind of thought process you guys had between saying that this is the point where we need to step in and start talking about federal law, especially as opposed to maybe state law?
Yeah, good question. I mean, Congress is not always the best at forward-thinking technology policy and implementing it. It's no secret. So we're very careful and deliberative. But we just heard story after story of how destructive this is, and really how no legal remedy was in place. And obviously, technology and the internet doesn't adhere to state borders. We also looked at the patchwork of state laws, some good, some bad, some just downright ineffective. So it really seemed appropriate to address this at the federal level in a way that took into account both the realities of the tech industry, just the sheer volume of information they're going through, and to put in place something that really had teeth and that really served as a deterrence.
Carrie, maybe you can talk a little bit about that as well. I know on your firm's website you track some of these state laws, and you're probably been kind of working with a number of these states in terms of responding to victims. How do you see the differentiation between states and their responses and the availability of recourse?
So we have 35 states plus DC that have criminal laws, and we also have 35 states plus DC that have different criminal laws, and there's so much variation between the laws. And we have another 15 states that are completely holding out, and in those states, it's perfectly legal to take an image of somebody else's genitals and post it online. It's legal to do that there. So the need for a federal law, just to protect everybody is so necessary, but particularly in states where there is no lawmaker protecting them, no lawmaker that sees the value in sexual privacy.
Maybe let me back on this too. I mean, just in terms of online privacy, I mean, we traditionally have addressed that through federal law, right? Not state law. Can you talk about some of the work that has done in the past in terms of children's privacy or other types of online privacy where it might be kind of a model or a kind of a lesson as we're thinking about moving forward here.
Well, it's interesting. So we have actually supported the legislation at the state level in over a dozen states. But we also saw the need to support federal legislation, as we've done here. I think if you look at children's online privacy, we have federal legislation to deal with these types of issues. COPPA is one way in which we've dealt with kids who are under the age of 13 in particular. I do think that it provides an additional piece of arsenal for going after people who are committing these crimes, which is extraordinarily important, especially in those cases where you are victims that are in states that don't have protection.
And Mark, the FTC has obviously been involved in this thing as well. Can you share with us a little bit about what the FTC is involved in?
Sure. So I'm Mark Highcorn. I'm just speaking for myself today, not for the commission or any commissioner. And probably most relevant was our case against Craig Britton, who was running a revenge porn website. And we are a civil enforcement agency, and our Section 5 of the FTC Act gives us authority over deceptive or unfair acts or practices. So under that authority, we brought an action against Craig Britton and obtained a settlement. This man was allegedly soliciting photos from people through means such as he would pretend to be a woman seeking a woman on Craigslist, and then basically solicit photos from women with the promise that he would send his own in return, and then he would post those with their personal information on the website. So as Carrie talked about, and when you have the personal information in combination with the photos, it makes it searchable online. They start to come up and be associated with you. So we challenged his conduct as both deceptive and unfair under the FTC Act. In part, he was also pretending to be an unrelated third party and charging for removal, a significant amount of money for removal of the photos from the site. This affected more than 1,000 people. That was an action we brought a couple of years ago. We've also been involved in sort of related areas. For example, we brought a case against a keylogger called Remote Spy that was advertised as sort of something that could be used to, you could trick somebody into downloading it surreptitiously, basically, and it would get on their device and then sort of capture information from them and report to you about location or passwords and things of that nature. So that's some of what we've been doing. There's a lot of other types of cases that we've brought as well, and I guess one thing I would say is that a lot of this debate is colored by the fact that there's an assumption that these photos were originally taken consensually in the first place, even though it's a limited scope, so that the individual has the idea, well, I'm sharing it with you, but I'm not planning to publish it for the world. And I just wanted to make the point that, a lot of our cases have involved situations where there hasn't really been any consent, even of that nature. So we brought a case against, TrendNet, which was a internet-based IP camera, basically, that you could hook up. And due to poor data security, even though you could set your feed to private, actually hackers could get around that quite easily, and they made feeds for something like 800 cameras available online. So another case that we brought was the designer-wear case, where people who were getting rent-to-own computers were, without their knowledge, getting the computers preloaded with software that allowed the rent-to-own franchises to determine their location, but also use the camera of the computer to take pictures of them without their knowledge or consent. So those are some of the things that we can do.
Yeah, maybe just stick with you for a minute. I mean, where are you seeing, that the FTC's hands are tied? Or maybe you see victims, or you see cases where you want to get involved, but obviously, the FTC is only one agency and it only has certain scope. Where are you guys not able to act?
Well, for one thing, we're a commercial agency, so anything we challenge has to be in commerce. So in the Craig Britton case, this was an individual who was, making money allegedly through this scheme and running the website as well as sort of like directly soliciting the photos himself. So if you had an example of someone who was like a vengeful ex-boyfriend who was just sort of posting it to some website, without a commercial motive, that would be something that we could respond to, for example.
Terry, let me bring you back on this. I mean, I think one of the things that's it's kind of maybe a defining characteristic of this type of problem is that there's so many different motivations or trajectories for how this happens. And I think, there's the Angry X, there's the pure entertainment value, there's the commercial, and so the responses have been so diverse. The problem with that is it creates a lot of, it's a heavy cost on the victim and the person affected by it to figure out, well, how do I deal with this? Is it a copyright issue? Is it a privacy issue? Is it a commercial issue? So maybe you can talk a little bit about that type of problem, because we see this in other areas, right, where exploitation is motivated for many different reasons.
Absolutely, and I really think it comes down to a consent issue. And the question is whether the victim consented to this particular use of intimate images of her or of him. If you could think of two analogies. One is the privacy of medical records. Clearly, people consent to the sharing of medical records, right? You want one doctor to share the medical records with another doctor, but you certainly don't want those medical records put out on the internet. Why? Because it might be shaming. That information might be used to interfere with your career, with your work ability to keep your job. That information simply may be something that is so private to you that it is crippling in the sense of people really can't continue to function when they think, oh my God, this is out there. People see this about me. So I think there's a real analogy between non-consensual publication of intimate pictures and the non-consensual publication of medical information. And I bring up that analogy because I'm very sympathetic to the First Amendment problems, quote unquote, with the idea of criminalizing the non-consensual publication of intimate pictures. And I think that when we think about the First Amendment, we need to think about why is it that it's okay under the First Amendment to prohibit publication of private medical records, but not to prohibit publication of private, intimate images and photographs and videos. I also think there's another analogy, and that is to sexual harassment in the workplace. Right, back in the 1990s, the First Amendment was used to resist the use of Title VII of anti-discrimination laws to stop sexual harassment in the workplace. The argument was, well, these are just guys being guys. Just because they put pornographic photographs on the locker of the woman, that's just, they need to be able to express themselves. And they have a First Amendment right to say, I don't want women in the workplace, and I can harass them with these images of a sexual nature. Ultimately, when Anita Hill testified about her experiences with this constant barrage of sexualized, harassing behavior by her boss, that was when I think people began to really understand that the First Amendment does not give carte blanche for people in the workplace to stop an individual from being able to perform her regular job duties. I think the same thing is here. Representative Speier said, there's no such thing as offline life and online life. It's life. We are all online a lot of the time. So I think the First Amendment argument is really, quite frankly, one that comes from privilege. And people who haven't experienced it, who are much more likely to be worried about the First Amendment problem. Those who have experienced the total shutdown that can happen to victims are much more willing to say, no, this is, we don't have the First Amendment right to do this to an individual.
Yeah, let me open that up to the whole panel, this discussion about, where you basically draw the line in the First Amendment, because I think that's probably been the single biggest hurdle towards moving forward in this space, because those people do recognize it's a problem, but then they say, well, should we be concerned about how this could go awry? And then, as you said, it becomes, this kind of, if you don't care about the issue at the warrant level, maybe First Amendment kind of trumps it, and that's been a big roadblock until, we've really seen movement for a number of reasons. We'll talk about that in a minute. But let me just open up to anyone that wants to talk about the First Amendment side of this. Maybe I'll pick on Josh to start, since you guys have been
Sure.
dealing with this quite a lot, I'm sure.
Yeah, I think ultimately, critics have basically said that this should be structured as a harassment statute, and that something inherent within this to hold congressional muster or constitutional muster would have to be harassment. And we strictly, like Terry said, see it as a privacy matter, and there's lots of jurisprudence that supports that. Financial data being another example. This is arguably more destructive to people's lives than an X-ray getting out or someone's Social Security getting out. And it's just the reality of the time we live in that this is a very real and pervasive threat to people's lives. And we see it as solidly withstand constitutional scrutiny. I don't know if this becomes law, knock on wood, if Secretary Clinton said she supported the legislation, so maybe this will be the first bill she gets to sign into law. But we'll see if it would be challenged in the courts. But I prefer to Dean Chemerinsky more than my insights on the legal question.
It's interesting. So what I would say, less on the First Amendment piece, but more on people's ability to share and to speak. We see on our platform where people don't feel safe, they won't actually share. They won't post their photos, connect with their friends. So for us, it's very, very important to create a space in which they can feel safe to share and connect. And so that's why we have these policies. It is that balancing, but we want people to feel safe. And so I think rules like this help, legislation like this help people to feel safe, to communicate in the ways that they normally would.
One of the things I think is just completely bizarre about this type of situation, so after the FTC case with Craig Britton, who was the individual who took action against. He was using a little bit of right to be forgotten type law to try and delist search results with his name, so people wouldn't find out that the FTC took action against him. And someone like that is actually more likely to be successful almost in protecting this, completely truthful, legal government public information about them than getting this, more sensitive information removed that illegally else have a right about there. Carrie, I know you've been thinking about this as well.
Yeah, well, I just think it's a problem for us to see this, particularly the Internet Privacy Protection Act, as pitting privacy against free speech. I think that's kind of a false tension, and I think we really saw that play out in the Hulk Hogan versus Docker case, where there were so many headlines that were talking about this issue between privacy and free speech, and they're just not diametrically opposed. And if we just think about what we've said all along, so much speech would be silenced if everything was considered a public matter. And really, in the Docker case, the question raised wasn't about privacy at all. It was about whether it was newsworthy. And we've had case after case in court finding that sex tapes are not newsworthy, even if they include famous participants. So.
Yeah, absolutely. I'm great you bring up that point, because also, we have seen these, the Paul Token case, the celebrity, iPhone leak hack, where we maybe had somewhat of a turning point in culture, right? Where one, this issue is more recognized. Maybe that's the kind of need help moment for this issue, where we finally are saying, wait a second, this really seems like something's wrong. Again, I just want to open up to the panel. How have things changed, in these past 2 years as we've had these high-profile cases, we've had kind of high-profile victims speaking out? Has that shaped how we're now approaching this policy?
Well, I will just tell you from my perspective, I think that there has been, there's a growing movement among women online and women in tech to push back against a lot of the quite gendered harassment and bullying that you find online. I think Gamergate sparked, that was an incident in which a number of women who are developing video games, which is a very male-dominated part of online industry, they began to be attacked very viciously, more and more viciously, and were quote-unquote doxxed, which is a little bit like the intimate, what happens with publication of intimate pictures. Their home address, all of their information was put online solely for the purpose of harassing them, simply because they were women who were invading the space of gamers. Women began to organize and push back against that. And I think that there's a growing awareness sort of generally online of the existence of this kind of bullying, and how gendered it is, how very disproportionately it impacts women. And so when you see these incidents of, for example, Leslie Jones and other victims of publishing intimate pictures, it comes with a cognitive base. I mean, it hits people with a cognitive base. They're already beginning to be aware of Gamergate. They're beginning to be aware of the bullying online. And so I think it fits. This new bill, I think, is something that people will recognize, describes a problem that people will very much recognize.
Josh, do you want to explain this? I know your office specifically reiterated that this is not the government bill.
Yeah, so I guess some have interpreted implicitly that our bill was somehow a causal reaction to the Gawker case, and in fact it was not. The question of bona fide public interest, I do think, is a compelling one, and the one that was brought up with the Hall Coding case. I think a more interesting example is some news organizations calling into question, well, what about Abu Ghraib? Should that photo be somehow prohibited or expose them to criminal liability? And I mean, just look how one, we don't dispute that it was in a very important story and a very, very important picture, but when you saw most news agencies, I haven't seen any news agencies that didn't do this, they blurred out the faces of the individuals that were naked and their genitals. And I don't think that in any way detracted from the power of that image or its importance or the effect. But I think it would be gratuitous and unnecessary to not blow those people's pictures or faces out, that would essentially re-victimize them, and in no way would create any sort of greater information to the public. So I think the bona fide public interest question is a real one, but I think that if you use some common sense and look at where the courts come down on some of these cases, that I think it's would easily be interpreted.
Well, I think there's been such a huge cultural shift in the last 3 years. I mean, not only have we gone from 3 to 35 states that have laws, and we've had some of our most celebrated celebrities come out and talk, like in Vanity Fair, about being a victim. But we've also had several civil cases that are resulting in really large judgments. We just had a new one for $500,000. We've gotten the FTC to bring a case against a revenge porn operator. We've got several federal outcomes against other operators. And then we have tech actually, creating policies. All this happened in the last year, or 3 years rather. And I think all of it together has given the media the okay to actually be writing about it, which never happened 3 years ago. Now there's articles about, from the perspective of the victim, and it's really educating the country about this.
So I want to spend a little bit of time talking about, basically what victims can do right now and what's available. So, we can start with you and talk about, kind of the actual mechanisms in place on Facebook. You guys were obviously one of the earliest movers, and it's been replicated in many ways in some of the other platforms. How you see that, kind of maybe walk us through how you both crafted the policy and maybe how it's actually coming out in practice.
Well, so on Facebook, we, as I said earlier, we do not allow this kind of sharing of intimate images, and we make it very, very easy to report, and when people report it, we will remove it immediately. But I think it's more than that.
Can you just, sorry, let me stop you there. Can you talk about what that renewal process actually looks like? Is there someone reviewing it on the back
So
end?
yes, we have a multitude of people around the world who reviewing reports 24/7 in over 40 different languages to remove them. But in addition, I think there's something that happens with this particular type of sharing that is particularly devastating for victims, which is that it's shared across multiple platforms. So if it's removed from Facebook, it may pop up somewhere else. And so one of the things that we did, working actually with the Cyber Civil Rights Initiative, was to collect how do you report this across a variety of platforms in one place, so that if you're the victim of this type of crime, you can go to one place to find out how to report across all these different platforms. Another thing we've done is we've worked very closely with NMED on guides to give people the resources that they need when they are the victims of something like this. So they can go, they can find, can they reach out to NMED, what are the local resources in their area, and we've been testing a reporting flow where those resources will be provided immediately upon reporting that.
Carrie, you can talk a little bit about this as well, and how you see this.
Well, we're continuously talking about what victims should do, and whether it's a copyright or a civil suit, but really what we should be talking about is how we deter the offenders, and that's why we really need the criminal laws. Offenders are not afraid of being sued for a copyright infringement or being taken to civil court. They're not usually people that have money, and they're often abusive exes, and so they would love to get back together with their victim, even if those if they're dating in courthouses. But what people are afraid of are going to jail and having something on their public record. So there's such a need for the criminal law so that victims don't have to think about what to do, because they won't be victims, because offenders won't offend at the same rates that we're seeing.
No, you're right, that's a very important point. Mark, that's part of the FTC's law. You, in terms of your enforcement actions in general, not you. It is, the FTC doesn't go after everyone, right? It's really trying to set a culture within the commercial space. Do you think that's been set through the actions? Are you seeing a change in, what people are willing to do commercially in this space that, has implications?
Well, I think that our actions probably have the most effect in sort of like the legitimate company space, frankly. And so we do a lot of like anti-fraud work and so forth, and work of this nature against sort of basically individuals. And we certainly hope that will have a deterrent effect. But some of these people, a lot of this is not necessarily rational behavior in the first place, obviously. It's driven by a lot of really ugly emotions, or even you wonder about mental illness or other things going on. So it's harder to deter that. I just want to go back to one more thing about helping victims, which was that we, on Monday, put out a piece on stalking apps. We do a lot of consumer and business education and this is a piece for women who sort of, sometimes an ex will sort of basically know where they are at every moment and be able to track them and sort of maybe even brag about, I know you went here and there. And just about the fact that these stalking apps can exist, and sort of how you might be able to find out that your phone has been jailbroken and that these apps might be on your device, and sort of what to do about it. So that was something that we put out just this week. And then we have other information online. For example, there's another piece for victims of domestic abuse and so forth, advice for them.
Hey, Terry, maybe you can talk about this as well, in terms of this kind of broader sense that this is a digital representation of issues that have long been discussed. The traditional response, I think, from individuals, if they feel like someone's sensitive, at least they think should be illegal, they call the police. And one of the problems that we saw when we looked at this was that a lot of local police aren't going to know how to deal with this issue, even if they escalate it to the FBI because it's cross-border, or they call it internet crime. There's still not really that same type of response that we would have for other types of domestic violence or sexual violence or anything like that. Are you guys thinking about kind of how this fits into that broader set of resources that are being made available?
Yeah, it really is a problem. What women like victims of sexual assault who are immediately not trusted initially, that what they often find, they go to the police and they're subjected to, we don't trust you, we know you were lying, where were you, what were you drinking, what were you wearing, what did you say, all the reasons why the victim might have been at fault. I think what you have in this, in publication of intimate pictures is the same kind of victim blaming, right? There's a lot of slut shaming. Why did you allow that picture to be taken in the first place? It's your fault. You should have known. You should know to protect yourself at all times. So we do see a lot the same kind of victim blaming, and there's a spectrum of perpetrators. The perpetrators really do fall along a spectrum of motivations for why they're doing what they're doing. Sometimes it's revenge. Sometimes it's just control. Sometimes it's just a predator who is using intimate photographs as a tool to continue to control an individual. It's very much true in the sex trafficking world. It's very much true in the world of domestic violence. So when you're dealing with a predator, it's particularly important to have the criminal law of the United States in that country.
Well, Josh, let me go to you now. I think what we should do is I want to have people in the room who I think probably have a lot of questions here, so I want to open it up. But I want to spend a few more minutes talking about the law itself, the legislative proposals out there. Can you walk us through, maybe a little bit more detail, how you've thought through some of these different issues and put it in the bill, and then I want to open up to the panel for their reaction as well.
Yes, we looked at a lot of stuff. We looked at the Digital Millennium Copyright Act, basically the process of notice and takedown for copyright material. We looked at child pornography and NICMIC, which is the National Center for Exploiting Innocent Children, which is kind of this quasi-governmental entity that's a clearinghouse for child pornography to try to come up with a model for some sort of notice and takedown regime. And neither solution seemed to really work. So what basically we really wanted to go after, we wanted to deter the really bad actors, like you said, these folks that are uploading the content, and then we wanted to get after the revenge porn sites or the non-consensual pornography sites. And how they're getting that information, or how they're getting this content is they're knowingly soliciting or advertising for this content. So basically, we define what this content is. We carve out police activity for investigation and the bona fide public interest, but basically say that if you're knowingly uploading or sharing this content, that you, with reckless disregard as to whether the individual consented for it to be publicly distributed, that you would be held criminally liable with a maximum penalty of up to 5 years in prison. And then we carve out and don't touch Section 230, which is the rail of this issue and many others, that basically if you touch it, you break the internet, people say, so we didn't want to touch that. And the good actors like Facebook, that really is not only in their self-interest to be vigilant about taking this content down, but do a pretty good job of it. But, so again, we really wanted to go after the bad actors, both the folks uploading it and the ones trading and benefiting and profiting the websites from selling this content.
So let me just open up the panel in terms of, I know everyone here has looked at the bill. Mark, I know you might want to comment some of the questions. But, just looked at the bill, your reactions to the measures, anything you particularly pleased about, anything you'd like to see changed if it's reintroduced?
No, well, like I say, I think the most important piece of it is that it shows that the United States government is on the side of women who are struggling with this issue. I think it's extremely important to get the word out that women will have recourse, that we needed a bill, as Josh said, as Congresswoman Speier said, we needed a bill with teeth. And this is something that women really can use, and I think it sets a tone. If you go back to that spectrum of perpetrators, along the spectrum of people who might not be the predators, deliberately creating tools that they can use to control individuals in sex trafficking or who are domestic abusers. Go on the other side of the spectrum of people who simply might be, oh, I'm going to get back at her, a true revenge porn situation. A criminal law could deter that, and I think will in many cases, and that's extremely important.
I'm a fan. Cyber Civil Rights Initiative was pretty active in working with Josh to draft this bill, and we think it's terrific.
We're fans too. And in all seriousness, because this is actually a very serious crime, the behaviors that people who are sharing non-consensual intimate images, the impact of that behavior is devastating. It's devastating to the people who are in those photos. And we felt very strongly that it was important to support legislation at the state level, when we saw it happening, and as well on the federal level.
And I also want to say that the exceptions that are in there, I think, very much take care of all of the First Amendment issues, and I think that what Antigone said earlier is extremely important. The free speech of victims is dramatically increased by this bill. The ability of women to be able to say, to be able to be out there, to be online without fear, to know that the internet can be a safe space for them. But it's not just actual victims of non-consensual porn, it's also bystanders who fear that they might become victims, who are then shut down, don't want to go online, are fearful. And so this bill, I think, opens up a great deal of free speech, not for those who are privileged and are already using the internet, but for those who really need to be on the internet.
Yeah, I think that's a great point. One thing I didn't talk about at the beginning, you might be wondering why a group like ITIF, which is focused on innovation policy, is even involved in this issue. And a lot of this goes back to this idea that we've always advocated for the idea that technology is designed by choice, and we should be thinking about what type of uses of technology we should be creating, how what this vision is for how we'll be using it, and how we can promote more innovation. That only happens when you do create the space that people want to participate in, and that's a role that has both a government component and a private sector. I guess the last question I have before I want to open it up to the rest of the room, we have probably some state lawmakers who are going to be watching this event and hearing what's said today. We only have 30-some states with these laws. What's the takeaway for them? Should they be taking a step back? Should they be still moving forward with? Do we still want 50 states with these laws? What's the message for that law?
I'd say better, or something's not always better than nothing, but I would point them to the Illinois state law, which I think is really solid. And again, not crafting it as a harassment statute, but rather a privacy one, and making it a criminal offense.
And I think the advantage of moving forward and trying to get laws like this passed in all the states is that it educates prosecutors throughout up and down the levels of government, and it really gets the word out there to all of law enforcement that this is in fact a crime.
Yeah, I mean, we absolutely still need to maintain state laws, and all 50 states need them. The FBI is not going to be looking into every single case. We can't expect them to. They have much more discretion about what case to take. So we need our local law enforcers to be stopping non-consensual porn on a local level. And the Cyber Civil Rights Initiative has a model law on our website, which is very similar to the Illinois law that Josh talked about, which we would recommend that the 15 remaining states look to. And the other trend that we're seeing more and more is civil remedies. So we've been talking about how criminal laws really deter, but we should all have options. And so if a victim wants to take matters into her own hand, then there should be civil liability. And the good civil laws allow victims to sue and keep their anonymity and to get injunctions to stop the spread. And so they don't necessarily have to wait for law enforcement to act.
Great, well, let me open it up. Yes, if you just say your name and the affiliation.
Yeah.
We have a microphone.
Yes, my name is Jamal Abdulalim. I'm a reporter with diverse issues in higher education. I have a two-part question. The first part is if anyone can speak to the extent to which this is a problem on colleges and university campuses. And the second part would be specifically for Josh. I'm wondering how you envision this might play out if something takes place at an institution of higher education. As you know, if a sexual assault takes place at a college or a university, sometimes it's handled differently than if it had taken place anywhere else. So does the legislation, does it consider or should it consider anything special for colleges and universities? Thank you.
Can I answer the first part of that question? We are seeing more Title IX cases that involve revenge porn. We have one right now on a college campus that we're handling at my firm. But also, I don't know if you remember the Penn State issue that happened, I think 2 years ago, where a fraternity was maintaining a private Facebook page where they were uploading images of drunk and passed out naked sorority girls. And the particularly sad thing about that was that even though Pennsylvania had a law, they didn't apply it to that situation because I guess the law enforcers decided that the offenders didn't have the intent. They were just kind of trading baseball cards with their frat brothers. But also, right now, the Office for Civil Rights of the United States Department of Ed is investigating 3 cases that we submitted that all involve non-consensual porn, actually at the K through 12 level though. And it's not, these cases don't just involve non-consensual porn. One involves non-consensual porn that was not consensually reported. One also has the underlying sex act was non-consensual but was distributed around 13-year-olds middle school.
Yeah, we're totally aware of the huge problem of campus sexual assault and this sort of conduct on campuses as well. Congressman Speier has been extremely active and on the forefront of that. Regarding any sort of jurisdictional ambiguity, we don't really foresee that. I mean, I think it's pretty solid within a PA or PPG's jurisdiction, whether to take these cases up or not, and we encourage them to do so. And I think in a lot of cases, to your point, they defer to Title IX offense and having a school adjudicate these sorts of offenses. And I think the default should probably lie with a DA.
Thank you. Other questions?
Hi, my name is Claire Gartland. I'm with the Electronic Privacy Information Center. So I heard the right to be forgotten was raised earlier, and I wanted to explore that a little bit more. So Carrie had mentioned how oftentimes it's really challenging to actually get this content taken down from the internet. And I've worked on some takedown cases as well, and I've seen that firsthand, that whether it's a video or an image, this content spreads like wildfire. You can have 20, 30 pages of search results in foreign languages. It's really hard to get this content down. And even if we are able to bring criminal enforcement actions against the revenge pornographer and potentially even a website that's soliciting this content, that still leaves the question of how do we get this content down, especially from really shady websites operating in another country. And so the right to be forgotten, which I'm sure many people are familiar with, but allows individuals in the EU to request search engines to remove results from search results when content is no longer relevant. And I'm just wondering your thoughts here, whether that would be a useful tool for combating or relieving some of the stress for victims when that content is just impossible to completely remove.
Yeah, and actually, last year, Google, Yahoo, and Bing all created sort of this mini right to be forgotten when it comes to revenge porn. So that's been tremendous in terms of helping victims. But you're right. I mean, it's totally a game of whack-a-mole. We can never ensure a victim's pictures are going to be down permanently, because anybody who saw them has the ability to have uploaded them, saved them on his computer, and then could post them back up. I have clients who, part of their morning ritual, they get up, they brush their teeth, and they go to Google to see where their new images have spread. And then they spend the first hour of their day just sending takedown notices and filling out the Google form and asking for those search results to be taken down. So it requires constant maintenance, even though we do have the ability to request takedown from search engine results.
Could you also maybe talk about some of the challenges you see with the content that's not searchable, so WhatsApp or some of these other platforms?
Well, so especially among the younger set, the content, so there's a lot of different ways that the content gets spread. Oftentimes it's posted onto the social media page of the victim. Sometimes somebody will actually create a website with the victim's name as the URL and dedicate a whole website to them. Then there are revenge porn websites. One of the most pernicious problems is when revenge porn is published on an actual porn site, because then the victim's name becomes a searchable term on that site. So like Pornhub or X2 actually have their own internal search engines. So even if the victim gets her material down, her search results still lead to that site. But among the younger people that I've dealt with, they tend to distribute the images device to device or through apps like WhatsApp and Facebook Messenger, and so it kind of spreads in a different way, and usually, inevitably, at some point it winds up on Instagram or Facebook. But it's a real problem, like to figure out the extent of the spread when the material isn't on the public internet, but it's being spread in a more horizontal way.
Does anyone else in the panel want to comment? Any questions? Yes.
Hi, Dustin Bowles with Reuters. You all talked a little bit earlier about the challenges of balancing free speech interests and taking down content that you don't want on your platforms. Specifically, the question for Facebook. I'm just wondering, we've seen a number of issues in recent weeks and months showing content taken down, and then later Facebook comes and reverses the decision. Most recently, Vietnam War and napalm photo got a lot of attention. I'm just wondering if you can elaborate a little on how that process works, deciding deciding when to reverse course on the takedown? What are the factors that go into that decision, and who's ultimately making that decision? Thank you.
Well, so as I said earlier, we have a team of people who review this content around the world 24/7 in multiple languages. In the context of something like this policy, there's no reverse course. So if you share an intimate image with somebody, we take it down, it's not coming back up.
But in other contexts, when there has been a reversal, what is that sort of, what goes into that process of, deciding to remove an image or a video, and then coming back and saying it's actually something that is okay?
Maybe we can talk after, since this is about this legislation, but I can talk to you after.
Other questions?
I'm Janisha Jones, an intern in Congressman Mary's office from California, and my question is, you brought up bystander intervention a little bit earlier, and I was wondering if there are any campaigns out to help educate the masses. I know that the growing generation is very reliant on social media, and one of the campaigns that's been brought about for college campuses, the Obama administration brought out It's On Us. And my campus is huge on that. A lot of CSUs back in California have national days and weeks of awareness. So is there any bystander intervention campaigns or just campaigns about this issue that are out that we can spread around and show people so they know? Because I know a lot of people know that this is an issue but aren't that aware of it. So your thoughts on that?
There aren't any government-based campaigns. The Cyber Civil Rights Initiative is very dedicated to raising awareness, and it's a great place to go for information and for instructions about removing content. But it's certainly an issue that's ripe for a campaign.
Any other questions? Well, with that, please join me in thanking our panelists.